Hello friends, today I am going to say something in respect of an associated mark by giving this example. Suppose Mr. A is a proprietor or is a businessman and he is well within the knowledge of the value of the brand, and that is why he has registered his mark. But during the passage of time, or it is the demand of the business, he wants to alter, he wants to change or modify his trademark which is registered. So under such circumstances, what would be the situation? Let me say something in this regard. Mr. A is the registered proprietor of the trademark XYZ. Now that label has several parts and label is considered as a whole, which is already registered. Now he wants to pick up one device, let it be called device B from that XYZ label, and wants to get it registered. So what would be the legal position as far as that device B which has been picked up from that XYZ label? Whether that B, that is a new label, and that XYZ is a senior label, would be considered in conflict, would not be considered in conflict, or what would be the other legal situation? Let me discuss this in this video. Today I am talking about, as I said, about the associated mark, trademark. What is associated trademark? The definition is given in section 2C of the Trademarks Act 1999. Let me read this. Associated trademark means trademarks deemed to be or required to be registered as associated trademarks under the Trademarks Act 1999. This is the definition. Now, one question: whether the use of the senior mark, which has already been registered, that is XYZ as per our example, can be considered as the use of the junior mark, that is B, device B of that particular label XYZ. So that device B is but naturally is subsequently to be registered. It has not been registered yet. What would be the legal position as far as the use of that particular device B is concerned, or the junior mark is concerned? Can the use of the earlier mark be considered as the use of this junior mark? Before I give an answer, let me discuss certain provision as in this regard. I am talking about provision of section number 15, section number 16 and section number 55 of the Trademarks Act 1999. Certain criteria or the condition imposed by legislature for consideration of any mark to be an associated mark with the earlier mark. What are those criteria? These criteria are given in section number 16 subclause 1. First condition or criteria is this: first trademark is registered. That means the first trademark, that means senior trademark, is registered, or an application has been made for the registration of that earlier or senior trademark. Second condition is the said trademark is identical with the junior trademark, or let me say this: junior trademark is identical with the senior trademark. Another criteria: there must be same proprietor. This is very crucial. There must be same proprietor, meaning thereby the proprietor of junior mark and the proprietor of senior mark is same. Another criteria, in respect of there is one line, in respect of same goods or description of goods or services or description of services. What does it mean? It means that junior mark is to be registered in respect of the same goods for which the senior mark is registered or has been applied for the registration. Next one is, there must be resemblance between these two marks, and there must be deception or confusion as far as the use by the third party is concerned. In other words, these two marks, junior mark and senior mark, must be deceptively similar, and it causes confusion as far as the use of concern by the third party, not by the proprietor of these two trademarks. If the third party uses this junior mark, then yes, of course there is confusion or deception. So resemblance is there. Under such circumstances, if these criteria are fulfilled by the proprietor as far as junior mark is concerned, then it is the discretionary power of the registrar that the registrar may consider this junior mark as an associated mark, associated with senior mark. This is the provision, or these are the words given in section 16. Subclause 1. Now, section 16 subclause 3 plays very vital role as far as that question is concerned, whether the use of the trademark, use of the earlier trademark can be considered as the use of the junior mark or can be considered as the use of an associated mark. Let me read section 16 subclause 3 in this regard. Where a trademark and any part thereof are, in accordance with the provisions of subsection 1 of 15 section, registered as separate trademarks in the name of the same proprietor, they shall be deemed to be and shall be registered as associated trademarks. Here one question, or here we need to read section 15 subclause 1 before I go ahead. Now what is section 15 subclause 1 says? Section 15 subclause 1 says that where the proprietor of a trademark claims to be entitled to the exclusive use of any part thereof separately, he may apply to register the whole and part as separate trademarks. Suppose there is a label and it has several devices 1, 2, 3, 4, and that label, that is called senior label or senior trademark, which has already been registered, but that part, as I told, that part called B is to be registered, then the proprietor has to apply for that B as a separate registration. Now section 15 subclause 1 read with section 16 subclause 3, which says that that mark which is subsequently registered can be considered as an associated mark. So after the discussion of section 15 and 16, let me discuss section 55 of the Trademarks Act 1999, which plays very important role as far as the answer of the question is concerned. The question is whether the use of the earlier trademark can be considered as the use of the junior trademark or the next trademark or second trademark. This is the question. Now the answer is hidden in section number 55 subclause 2. Let me read it. Section 55 subclause 2 says that the use of the whole of a registered trademark shall, for the purpose of this act, be deemed to be also use of any trademark being a part thereof and registered in accordance with section 15 subclause 1. So if we read section 15 subclause 1 with section 16 subclause 3 read with section 55 subclause 2, we come to know that the answer is in affirmative. Yes, that can be considered. This is the legal provision. The answer is yes, the use of the earlier trademark can be considered as the use of the junior trademark. But these three sections can be required to be read as a whole and together. Friends, I hope you enjoy this video. Thank you very much.